some people believe that there is a good chance that the judge will certify it. And I don't think so. The only way I believe the judge agrees to certify an interlocutory appeal is if Ripple joined with them and agreed to do it.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
The big topic of the day, you see it all over crypto Twitter, is the SEC going to appeal? Are they going to seek an interlocutory appeal? Now remember, an interlocutory appeal is not an appeal of right. When you lose a case and the case is over, there's no jury trial left to do. There is nothing like that. And the judge renders her decision or the jury renders a verdict. Then you have a right to an appeal. But if you're trying to appeal before the jury trial, and there is a jury trial left as it relates to Chris Larson and Brad Garlinghouse, remember, and they're aiding and abetting, that one charge that of institutional sales, the judge said that gets to go to a jury, and it's up to a jury to decide whether those two executives were reckless in aiding and abetting Ripple's institutional sales. So the SEC doesn't get to just go up on appeal. They have to ask the judge whether or not she will agree to allow them to appeal. Now, I don't, and people disagree with me. Of course, a lot of people disagreed with me before, but some people believe that there is a good chance that the judge will certify it. And I don't think so. The only way I believe the judge agrees to certify an interlocutory appeal is if Ripple joined with them and agreed to do it. And if Ripple agreed and said, yes, judge, we agree because we want to appeal certain portions of your ruling as well. And therefore you have both sides agreeing to it. Well, sure. Then the judge could say, okay, I don't need to worry about a jury trial a year from now or 6 months from now. You know, you both want to take it up. You both think I'm wrong. Go ahead. In that scenario, I could see it being successful. But if Ripple were to object, for example, and say, look, judge, for 2.5 years during an investigation, this hung over these two executives' head. And then 2.5 years of litigation, it is hung over Brad Garlinghouse and Chris Larson's head. And now we're looking at a trial next year. Okay, all of this is hanging over their head, and it's dubious at best. And we want our day in court. We object to that appeal. And then say, look, this is just a Howey application. Gary Gensler and the SEC are going out there saying we don't need new legislation. We don't need new rules. This is a simple test. How many times has Gary Gensler said it's simple? The Howey test. Even in the SEC Coinbase case, they said that Howey is a simple test that provides everyone on adequate notice. So all this judge did was apply a test that has lasted for 76 years to XRP. It's not even the first digital asset case. This isn't unique. There have been other Howey applications to digital assets. Remember, we've got Kik, we've got EOS, we've got Telegram, we've got Library, now we've got Ripple. So there's nothing unique here. It can wait until the full case is over. I believe that that's the position that Ripple takes. There will not be an interlocutory appeal. Again, there are people out there that are smart who disagree with me, but that's my position. Also, you have to think about the appeal itself, right? What are the chances of appeal? And I want to draw everyone's attention to something that is important. If there was anything that made this decision appeal proof, it would be footnote 13. And I want to draw your attention again to footnote 13. Look at it. The court holds only that a common enterprise existed between Ripple and the institutional buyers. The court does not reach the question of whether the common enterprise extends to encompass other XRP holders, Defendant Garlinghouse and Larson, the XRP ecosystem, or any other entities. Okay, now what that means is that even if there was an interlocutory appeal, right, and the SEC said, which I don't think they will, but said Judge Torres got it wrong, and therefore we're going to remand it, basically. What it means is just that third prong, they would reverse the court, and then they would send it back down to her, and she would then have to apply all the other Howey factors that she didn't apply, okay, because she didn't apply them. So you can't, the SEC wouldn't just get this great, huge victory on appeal where Judge Torres's opinion has been thrown out and the SEC now has great jurisdiction over crypto. Bullshit. It's not how it works. Okay. How it works is they would say, Judge, you got it wrong. Now we're sending it back to you to finish the Howey analysis. So guess what might happen? What I've said in my tweet all along is that they're going to lose on common enterprise. So the judge would then say, okay, is there a common enterprise between Ripple and XRP holders? Okay. And that's hasn't been done. And I put a tweet out that explained this, and I want to get it right. I explained that in the Second Circuit, the only common enterprise standard to be adopted by the Second Circuit is horizontal commonality. Just know that there's vertical commonality and there's horizontal commonality. We're not going to get into much of it except to say that the Second Circuit is only adopted so far the horizontal commonality approach. And so what is that? What that is horizontal commonality is established when investors' assets are pooled together and fortunes of each investor is tied to all the other investors and to the overall enterprise, Ripple. In other words, think of the Howey case. Think of the orange groves and how each investor had a pro rata share of the oranges. And when they sold all of the oranges, each investor got to equally benefit, right? Based on what they had. It's all base pro rata, all pooled together, and they each benefit or lose. If there's a monsoon and it wipes out the orchard, right? The orange groves, they all lose the same. If it is the best orange grove harvesting in the history of the country, they all benefit equally. So I pointed out that with XRP, unlike the Howey case, you get to own your XRP. You get to choose what to do with your XRP, right? You might loan it out. You might collateralize it. So I pointed out, and this is in my amicus brief to the judge, I pointed out the Celsius bankruptcy and said, look, Judge, that proves, that destroys what strict horizontal commonality is, because those people who loaned out their XRP to Celsius, they lost. When Celsius goes bankrupt, they lost. That didn't impact me. It didn't impact me as XRP holder. I didn't loan it out. Okay. Didn't infect some of you, didn't loan it out. So there's not this equally tied together commonality that exists among all of us. Some of us benefit, some of us don't. If you're talking about a strict application of horizontal commonality, they lose. So even if the SEC were to win on this third factor, we come back down, she applies the second factor and can rule the same exact way. And let's remember, when it comes to common enterprise, the SEC sucks. They suck at it. They suck at applying it. I'm being honest. I'm not being facetious. They are so bad at second prong that they ignore it. In fact, let's go to footnote 10 of the 2019 Digital Asset Framework by the SEC. Look what they say about common enterprise. It's right there in the middle. The commission, on the other hand, does not require vertical or horizontal commonality per se, nor does it view a common enterprise as a distinct element of the term investment contract. Ladies and gentlemen, that's your SEC saying, we're just going to ignore that second factor of Howey. We don't view it as a distinct development. Well, you don't get to do that. You don't get to do that when you get before a judge who applies the law, whether that judge be at the federal district level, or whether that judge be at the Second Circuit, or whether that judge be at the U.S. Supreme Court. You don't get to choose to ignore the law, SEC. Okay, that's what happens. So just know that's why I put a tweet out there that said, this appeal issue that they're going to appeal, it's such a setback. It's not a setback. They don't even get to win on appeal. Okay, not win outright. And guess what? She could then apply the common enterprise factor, say you didn't satisfy the test. Remember their theory on common enterprise. The first time they brought it up in the complaint, the SEC said Ripple was the common enterprise that all XRP holders in the entire world were entered into with, okay? Then Ripple sent requests for admissions out that forced the SEC to admit that owning XRP did not give a XRP holder a legal interest in Ripple, the entity. Having XRP, owning it, does not provide any kind of financial claim to Ripple. So after the SEC had to admit that fact, they changed their common enterprise theory. Remember, they hired an expert, and the expert said that the common enterprise was the entire XRP ecosystem. He said all XRP holders, Ripple, Coinbase, Kraken, Uphold, and every other exchange, every market maker, they're all in a common enterprise with each other. Well, XRP holders and Ripple together got that SEC expert struck. That part of his opinion was struck. And when you, by the judge, and when you read the SEC's summary judgment motion, they don't cite to their so-called expert. So out the window went theory number 2 on common enterprise. So then when you read the SEC's motion for summary judgment, it says XRP represents the common enterprise. Wait a minute, your theory was XRP itself represents the investment contract. Now it also represents factor number 2 of the Howey test along with the investment contract. I mean, it's all nonsense. That's why I called it legal gibberish in my motion to the court, my amicus brief to the court. They're making this stuff up as they go, and that got rejected, and it got rejected summarily. But guess what? After the judge applies common enterprise factor, and if they appeal that one, it could come back down again, and she can say, well, guess what? Because your expert got thrown out, whether or not XRP holders acquired XRP for non-investment reasons or investment reasons, right? The thousands of XRP holders who signed affidavits talking about accessing the XRP ledger, accessing the first decentralized exchange in the world that's part of the XRP ledger, moving money, developers building on the XRP ledger who acquired XRP for that. That could be a factor. So the bottom line is, even on appeal, the SEC is never going to get a complete victory.